thank you ICA and FICCI for inviting all of us and organizing this conference, but also looking after us who have come, who are not from Delhi, very well. As Justice Shah said, enforcement is of course only needed when an award is not voluntarily adhered to. We're lucky on this panel to have experts from 4 different jurisdictions. So we have Singapore, India, Brussels, so Belgium, and so I will therefore cover English law. Enforcement means giving an award the same effect as a domestic court judgment. If one starts chronologically, the first award that one might want to enforce is an interim award. The important thing to bear in mind is that interim awards or provisional awards in arbitrations are not enforceable under the New York Convention. For example, in one of my cases, the other side sought payment, in fact, in summary proceedings, which we covered in the session before lunch. And this was, although it was a summary award, it was on its face titled an interim award. And we successfully resisted enforcement in India, in fact, relying on a Delhi High Court judgment called Raffles Design and Educom, which says that an interim award is only of persuasive value. And therefore, a tip that one may want to bear in mind is to have the award titled or seek at an interim stage a final partial award, but it must have finality. Without that, it would be difficult to enforce. The English Arbitration Act provides for enforcement in 3 different mechanisms. The first is the most relevant for most of you in the audience because it is under the New York Convention, and India and UK are both signatories to the New York Convention. The second is seeking permission to enforce, which falls within Section 66 of the English Arbitration Act and is useful for domestic English awards but can also be used for foreign awards. And the third, which I do not recommend, is bringing an action on the award. It is, in fact, bringing a new proceeding and using the breach of the arbitration award to start a new action on the award. So speaking of the first, which is enforcement under the New York Convention, although UK, India, and 161 countries in total are signatories to the New York Convention, there seems to be a misconception that awards passed in any of these countries can easily be enforced in another signatory state, when in fact, India has taken the view that it would only enforce awards of reciprocal states within the New York Convention. So for example, England is or the UK is a reciprocal state, and therefore it will enforce a UK seated award. But the UAE is currently not a reciprocal state under the New York Convention, even though the UAE is a signatory to the New York Convention. And so if you have an award from Dubai, which one would like to enforce in India, it becomes difficult because it's not a reciprocal state. Generally speaking though, if an award is passed in a New York Convention state and the assets are also located in a New York Convention state, and of course there is reciprocity, then enforcement should be straightforward. I'll just deviate to court judgments in this regard. So in relation to court judgments, when one needs to enforce foreign judgments, I believe India is only a signatory with 8 other countries in the world. So there isn't a convention like the New York Convention, and it only works on a bilateral treaty basis. So the UK again and India do have a bilateral treaty, but there was a case where there was a judgment of a Ugandan court, and Uganda does not have a bilateral treaty with India. So the way in which it can be enforced would be to have the Ugandan judgment recognized as a judgment in England, and once it is recognized as a judgment in England, it can then be brought to India to enforce. How can one resist enforcement if one is on the other side? There are several defenses to enforcement which have been set out in Section 103 of the English Arbitration Act. The first is if a party has some sort of incapacity and was under that incapacity at the time that the arbitration agreement was entered into. For example, if one was a minor or a party was a minor, which has recently been covered again in Delhi by the Daiichi Sankyo case, but I will leave it to my colleague Sanjeev to speak to you more about that. The second is if the award covers issues that do not fall within the terms of the arbitration, or if the composition of the tribunal was not in accordance with the agreement. One may think that this isn't very easily possible, but I came across a case which had an LCIA arbitration that required a cement expert to be at least one member of the 3-member panel. This was not the case, and we successfully managed to resist enforcement because the arbitral tribunal only consisted of lawyers and barristers and retired judges, but no cement expert. And the next defense to enforcement is when an award is not yet binding or has been set aside by a court of a country where the governing law applies, or a court of the seat. An award in respect of a matter that is not capable of settlement, is not capable of arbitration, such as serious fraud, can also be resisted. And our favorite defense, which is public policy, which no doubt other members of the panel will also cover. All of these defenses under English law are discretionary and not mandatory, and therefore a judge in England can decide whether or not they wish to apply any of these defenses. The uniqueness about English law versus Indian law is that under English law the defense can be taken in England even if it was not challenged or appealed at the seat, which is slightly different from the Indian position. The second mechanism that I refer to is a sort of summary procedure. And this is basically seeking permission to enforce the award and tends to be used more for domestic English arbitrations rather than foreign awards. A judgment may be entered in identical terms to the award, but care should be taken, if it is a foreign award, not to merge the judgment together with the award, because one must remember the New York Convention has many more signatories, whereas court judgments only have bilateral treaties. Two tips that one can consider and think about, and in fact some of these can be used even before the arbitration begins to help and assist in enforcement at a later stage, are freezing injunctions and the appointment of receivers. So freezing injunctions, and again the English courts are able to and do grant worldwide freezing injunctions. And these can be secured before the arbitration begins, as well as after an arbitration has been completed, so post-award. An example, not an arbitration-related example, but a court-related example is recently that Mr. Malia's assets were frozen by an English court following a DRT judgment in India. The appointment of receivers is also useful, but one needs to bear in mind when one is enforcing across borders. For example, if there is a receiver in England over Indian assets, the English receiver will need to provide a power of attorney to somebody who is local for them to actually be able to carry out the enforcement procedures in India. Also, one needs to think through the FEMA provisions and whether, for example, checks are handed over to the power of attorney holder in India, they can be deposited and money can be taken out of the country. I very briefly, with permission of the chair, would just like to cover a few points on Brexit and arbitration, as some of you in the audience have asked me that through the course of the day. If I may, just for a minute. I have 2 minutes. Brexit is not going to affect the enforcement of arbitration awards, certainly not awards seated in London. And this is again because of the New York Convention. All 27 EU states are signatories to the New York Convention, and therefore English arbitration awards will be easily enforced in EU countries as well as in other reciprocal territories around the world. Another, in fact, added advantage following Brexit is that England will be able to pass anti-suit injunctions against proceedings that may have been going on in parallel in EU countries. This was prevented during the time that the UK was a part of the EU, because there were judgments that prevented any EU member state from passing anti-suit injunctions, preventing another court of an EU member state to proceed.